Dear students, let's have a look at Section 6 of Hindu Minority and Guardianship Act 1956. The Supreme Court judgment delivered on February 2, 1999, declaring the mother as a natural guardian of her children, is hailed as a path-breaking one in the realm of Indian family law. The case is Geeta Hariharan versus Reserve Bank of India, 1999 to Supreme Court cases 228. Many have interpreted it to mean that women will no longer be haunted by the fear of losing custody in matrimonial disputes, as now they are elevated to the status of natural guardians. In my view, this is rather an exaggerated rating of the judgment. The issue of the custody had already been decided in women's favor in many earlier decisions. In the present case, the apex court did not address this issue. The question before the court was a limited one, whether mothers could also be deemed as natural guardians during the lifetime of their husbands. Section 6A of the Hindu Guardianship and Minority Act 1956 stipulated that the father is the natural guardian of the minor and after him the mother. The court reinterpreted the words after him to read in his absence in order to arrive at a harmonious interpretation of the constitutional mandate of gender equality. The court spelled out certain situations: A. When the father is indifferent towards the child. B. If the child is in the exclusive custody of the mother. C. Due to the physical or mental incapacity, the father is incapable of acting as the guardian. D. When it is decided mutually between the parents that the mother will act as the guardian, where the mother could be deemed as the natural guardian even during the lifetime of the father. A point to note is that only when the father has abdicated his responsibility or by consent agreed to elevate the mother to the status of natural guardian would the judgment come into effect. But in keenly contested custody battles, this judgment will not be relevant. The perceived revolutionary impact of the judgment, even on this limited question, gets diminished in the context of an earlier decision delivered in 1970, that is Jijabai Gajre versus Pathan Khan. The principle that a separated wife can be deemed as the natural guardian of her children had already been upheld in this case. An agreement entered into by the mother who had raised her daughter single-handed had been validated on the premise that when the father is absent, the mother is deemed as the natural guardian. Several misconceptions govern issues of custody in matrimonial disputes. Guardianship implies the proprietorial rights and custody implies the responsibility of raising a child. While there was a leaning towards the father, in issues of proprietorial rights, the mother's role as a caretaker of her children had been granted due recognition for well over a century. To give a brief sketch of the history, the concepts of custody and guardianship in Hindu Minority and Guardian Act are delivered from the Guardians and Wards Act of 1890, which in turn was based on English family law. Soon after divorce was granted statutory recognition in England, in the mid-19th century, separated and divorced wives challenged the natural guardianship of their husbands. It is in this context that the principle that the best interest of the child is paramount started gaining recognition. By mid-20th century, the principle became one of the primary pillars of the family law in England. Even a wife who had committed a matrimonial fault could be awarded custody of the child. The courts held that the aim of matrimonial litigation is not to punish the guilty, but only to ensure the welfare of the child. It is impossible to rule that just because a woman had once committed adultery, she was not a fit person to look after her child. If the welfare of children requires, even an immoral mother can be given custody, the English courts proclaimed. The Guardians and Wards Act 1890, one of the first Indian statutes to address this issue, incorporated the tension then prevailing in England. While Section 19 stipulated that father is the natural guardian of the minor, Section 17 prescribed that the welfare of the child is paramount. Despite the wide variations regarding parental right of custody in the diverse personal laws, courts in India have taken recourse to the principle best interest of the minor to award custody to the mother. The best interest maxim overrides the stipulations in different personal laws and is applied universally in all custody litigations. To deprive a child of tender age of its mother's love and care would not be in the best interest of the child has been the well-established legal doctrine. This concept was awarded statutory recognition under Section 6A of Hindu Minority and Guardian Act, which prescribed that the custody of the child below 5 years should ordinarily be with the mother. But this doctrine cannot be extended to imply that once the child is older, the custody will automatically revert to the father without ascertaining the wishes of the child. Courts do not view the child as the object to be tossed around between the warring parents. Since the child remains unrepresented in the matrimonial disputes, it is the duty of the court to ensure that the child's interests are not harmed or negated. Hence, women's anxiety that once the son enters his teens or the daughter reaches puberty, she or he will be snatched away and placed in the father's care against the child's wishes are generally baseless. But the best interest of the child doctrine is more complex than it appears on the face of it. When the father is wealthy and the mother has no independent source of income, where would the best interest of the child lie? Way back in 1920, in two significant cases, the courts ruled that just because a mother does not have same financial resources, it does not mean that she should be denied custody of the minor children. The later decisions have reaffirmed this premise. While non-working mothers are haunted by the fear of lack of monetary resources, working mothers are faced with another set of tensions. Would a mother who has paid employment and spends most of her working hours outside the home be a better caretaker? Right up to the 80s, the issue remained unresolved, but more recently, it has been held that a mother cannot be denied custody on the basis that she is gainfully employed, and now this reasoning has become an established principle. However, it is rather wishful to presume that the Indian courts should grant custody to a woman who is living in adultery. The decisions on this issue are ambiguous. So while the courts had gradually changed the parameters of awarding custody from natural guardian to the best interest of the child, the social institutions lagged far behind, causing endless hardships to women. One institution that consistently humiliated single mothers is the school system. Usually, divorce brings about a change of residence for women and consequently changes of school for their children. Women were constantly pressured to obtain their absentee husbands' signatures on school leaving certificates. Banks and passport authorities also remained conservative in their approach and revered the role of the father as the natural guardian. They viewed him as the only parent equipped with the ability and the social responsibility to act on behalf of minors. It is in this area that the Supreme Court judgment has brought about a significant change and sent out clear signals that decisions made by the mother are equally valid. With this, I hope all of you understood the point clearly regarding Section 6 of Hindu Minority and Guardianship Act 1956.